Still number 1, Mr. Shankar Rangareji.
Is there anyone for petitioner? Not connected.
Not.
What is the matter? Whether time is required in the new legislation. Man, have been served? You are appearing. The challenge the validity of the rules has already been disclosed by this book.
Copy has not been served, but though it is shown as we couldn't locate the file. Last. Lordship, can you have it on Monday?
We'll pass it over, let him come. Pass on.
Still number 2, Kiran J.
The respondents have auctioned the INO belonging to the petitioners, Mala. Pursuant to the auction, Mala, the amount which is with them, they have not yet returned the amount to the petitioner in spite of giving representations, Mala. They given several representations from initial A1 to A2. In fact, it's covered by judgment. Mala, Supreme Court has said after the e-auction, it has to be handed over to the petitioners. Admittedly, the iron ore belongs to the petitioner in the stockyard. They have e-auction. I have no right to sell. It is only the respondents who can sell. After selling, they have retained the money. They have to give it to us.
May I make the prayer in this petition is to consider their representation. We have issued a final notice on 28th January 2022, calling the petitioner to submit documents for considering this case.
28?
January 22.
Today is only 21st January. No, we are in February.
Sorry.
And thereafter not on.
He has not responded to this notice.
I don't have a copy.
Today,
Today,
first time it is coming.
No. We want to know if you have served the notice to him.
Yes.
He has not responded. This is your case.
He has responded.
Kindly show that you have served the notice.
We have served. He has responded on 4/2/2000. Next document.
4/2.
Yes. 4/2.
Yes.
4th February. Thereafter, one more notice on 16/2/2022 we have issued, calling for hearing.
Calling for?
Hearing. To appear before the authority. And he has appeared on 19/2/2022.
Then?
His case is under consideration. Lord, we will consider his case within a period of 3 months. That is all.
Dispose of?
Yes, sir.
I'm sorry, Manoj, I'm not instructed.
Complete instructions have not been given to you.
My apologies, Manoj. Otherwise,
No, it is not your fault, your client's fault. He did not inform you that he has been participating there. Subsequent to the final notice. What? What is the name? Senior advocate for the petitioner, the notice for respondent number
123, Manoj.
1 and 4.
1 and 4 shall be accepted for by General Government Advocate for the order proposed the notice to second and third respondent is dispensed with. The petition has been filed seeking following relief. Then the counsel for the petition submits that in view of the judgment of the apex court in the state of Andhra Pradesh and others versus Obula Forum Mining Company Private Limited and thus 2013 Volume 8 SCC 216 petitioners are entitled to get the amount of rupees 2,19,58,769 derived from the sale of 11,999. What is empty? Metric tons of iron ore from Banihati stockyard to e-auction dated 9/3/2012, 8/2/2013 and 14/1/2015 along with interest. The respondents have not taken any decision on the, in spite of representation having been made. Representation dated 8/8/2019, 20th of July 2021 and 31st of October 2021. Said by the petitioner to respondents. Mr. S.S. Mahendra, Sara, Leonard AGA, appearing for first and fourth respondent, on the other hand, submit that in this regard, a final notice.
I mean, can I intervene? My learned friend is, because it pertains to Ramgarh village, Nandur Taluk. The petition is regarding some other place, madam. And I think my learned friend is.
No. It is.
Ramgarh village, survey number 35, Ramgarh village, Nandur.
No.
The petition is pertaining to Kungar. Same company, madam.
No.
Different stockyard. Let them take a decision, madam. Irrespective of that.
Lord, it is in respect of VSL Mining Company Private Limited.
Whether it relates to same matter or some
Yes,
other.
Lord. My instructions are that, Lord, it relates to the same matter.
Can I make one submission? Petitioner has got 6 stockyards. One of the stockyard is what my learned friend is saying. There are 5 other petitions. Irrespective of that, let them take a decision within a limited period of time.
You take inspection on this. We will have it in the revised list. You just get it confirmed whether they have.
Because the notice itself is very clear. Lot of just have a look at it.
We do not know. You take instruction on telephone from your client
We'll do that.
as to whether they have received this notice and whether they have responded to the notice or not.
Please, I'll do that
Or
right away.
whether it is with respect to some other stockyard or something like that.
I'll do that right away.
We'll have it in the next revised list again
Please.
after the fresh. Just keep that order. Yes, it's there. If it is, then we will complete, otherwise we'll continue.
Number 3,
You're also having on Friday or some.
No, we'll take up after some time.
Oh, sorry. Just to.
In the revise.
Please, sorry.
That is why we said you take it on the telephone
We'll do it
instructions.
Because usually you refer to as Passover.
In the revise means the Passover.
Sorry.
Here we use
number 3, Lokesh KV.
Appear for the appellant in this case, Milords. Milords, may I pray for listing this matter along with WA number 36 of 2022, Milords. Both are pertains to same circumstances, facts and circumstances.
Who are you? Who is the appellant?
Milords, appellants is a bank, Milords. The respondents are the borrowers.
You were respondent in the
Yes,
court.
Milords. We were the respondents in below the lower court, Milords.
What was the matter before the report?
Milords, the respondents had defaulted in loan dues, which they had obtained from the appellants. The respondents had approached Honorable DRT challenging the position notice issued by the bank. The DRT had granted an interim order imposing certain conditions. The appellant wanted additional time for complying those conditions. So he challenged the position notice again and before the honorable single bench. And the single bench had extended the payment conditions to up till March 15th, March 2022, 15th March 2022. That order is under challenge, my lords.
Para 2 is a consent order. You had agreed for this order?
Yes, my lords. I only have one modification in this order, my lords. I only want EMI dues. The order may be modified. At least the entire EMI dues until March may be cleared. No, that's the only my the only my grievances account will still continue to be in a non-performing asset in spite of making payment of.
Go and make a clarification. Go and move a review application in this matter.
I will.
It is
The matter is disposed. Matter is disposed, my lords. Again, a review might not be.
You will have to file a review.
Obliged, my lords. I will file a memo for withdrawal, my lords.
No, what is his grievance? Will dispose it off with liberty to you to file review.
Obliged, my lords. Obliged.
This writ appeal has been filed challenging the order dated 9th of December 2021, passed in writ petition number such and such. The appellant, being the respondent before this report, has filed the instant appeal submitting that EMI was not paid by the respondent petitioner, and in case EMI is paid, the bank account of the respondent petitioner would come out of NPA.
NPA, my lords. NPA.
And he wants this much of modification in the impugned order. From the perusal of the order under challenge, it is very much evident that the writ court has disposed of the writ petition on the concession having been granted by the appellant oblique respondent bank, and the impugned order is a consent order, and as such we do not find any reason to grant indulgence. The writ appeal is dismissed, however, with liberty to appellant to move appropriate application in case he intends to get the order modified or reviewed.
Obliged.
Number 4. Government appeal.
the statement. This matter pertains to Millards Act 7 of 2014. Millards validity or otherwise of Act number 7 of 2014 is under consideration before a coordinate bench. Special bench is constituted to consider the validity of Act 7 of 2014. This matter also may not kindly be clubbed with writ April 2014. 2014 writ of 2417 of 2015 minutes. 2476 of 2015.
Connected with some please connect it. I don't understand.
The Rajshekar Leonard AG submit that the above matter is connected to
2476
2476
of 2015.
of 2015. Registry is direct connect this matter to the said matter.
There's an interim order in that matter not to precipitate the matter.
We will not pass any interim order. We have not heard the matter on merit. You said that you connect with that. We have connected it. That is all.
And I kindly.
Not, this is not the way. First is,
Please, sir.
if you matter, you only said that such matter is pending, so we have connected with that. Let it come along with that.
I'm sorry, the presentation was not correct. Sorry, but that I should have stated it first. Since similar interim orders have been granted in batch of those petitions, my lord.
Connect with, give a short date. We'll consider interim relief on the next day.
But there is a contempt petition, my lord.
Sorry.
3. Number 5, give it Diana.
Lordship, the respondent is a financial institution. The appellant is the borrower. Respondent filed before the arbitration for recovery of rupees 17 lakh.
Mr. Danan, there is a issue raised on maintainability and there are some
Maintainability. I filed a commercial appeal. The appealable order, section 37 of the Arbitration Conciliation Act. Section 37, class C. The doubt is whether it comes to commercial appeal or miscellaneous appeal.
not been produced, Mr. Danan.
No, our copy have produced. At the
Not here.
page number 19, Your Lordship.
It is not here. That is the office objection raised that from page 15 to 22.
That award I have challenged before the.
Mr. Danan, please understand. From page number 15 to 22 is not there in your filing. That is the office objection which has been raised. Our copy is not before us.
I will comply that.
Registry has raised an objection as regards maintainability of the commercial appeal. The above appeal is being filed under section 37(1)(c) of the Arbitration Conciliation Act 1996, challenging the dismissal of the section 34 petition filed by the appellant herein. The issue is has arisen since the section 34 petition was disposed of by the additional district judge and not by the commercial court. Be that as it may, the remedy for challenge of a disposal of allowing or rejecting a proceeding under section 34 would have to be filed before the commercial appellate jurisdiction. The above petition is therefore held maintainable. Then counsel for the petitioner seeks for a week's time to comply with other office objections.
Number 6. Qualification.
I appear for the petition, my lord. Office objection number 1 and 2 complied, my lord. Court fee is paid and the copy is served on the government advocate. But this is a PAL, my lord.
Let it be placed before the full bench,
Please, my lord.
larger bench which is dealing with the matter.
Please, my lord.
It is relating to hijab.
Please, my lord. My lord, this I made the reporters, the media houses as respondent number 3273, my lord. The reporters and the cameramen surround the institutions. They chase the girls who wear hijab and
All right. It is informed that the issues involved in the petition relates to hijab controversy. As such, full stop. The cases in this regard are being considered by the larger bench in leading case number such and such list along with the petition number such.
public.
230.
Please, my lord.
Same bench will consider, not this. At that time, point out the office objection.
Number 7.
My lord, may I submit, my lord? My lord, my name has been shown as representing the government in this matter. I have not been appointed by the government in this particular matter, my lord. In other two PIL matters, they appointed me. So I cannot appear in this matter. My name has been shown by the government advocate, my lord. He is submitted to the court that my name may be shown. I have not been appointed by the department, my lord.
But the government will appear. Earlier, my lord, sir, Madam Revati was appointed as special counsel. Now that, madam, we will continue, the state government will continue to offer.
What are your instructions?
My lord, I got it verified. In this matter, madam is, my lord,
To forget about madam, what are your instructions when the courts would be established?
both we have filed compliances. Compliances have been made.
You were granted time on the last date to seek instruction as to within what time these courts will be established.
My lords, this already compliances is made. My lords, provision is also made. My lords, in all the district courts, my lords, I have instructions to submit. These matters to be made over to the courts where, my lords, the regular courts are functioning. And even, my lords, the counsel who are there, my lords, as public prosecutors, they be appointed as, my lords.
Rajshekar, last time you took time to make submission as to seek instruction and make submission. As regards whether the special courts have been notified and whether they are functional.
Notification, my lords, notification is made. Kindly, my lords, my compliance affidavit, my kindly be taken. Compliance affidavit dated, my lords, 18/2/2021.
Whether these courts have been notified?
Notified, my lords. It is notified on 23/10/2019 itself. It is notified. I have produced a copy of the notification, my lords.
Are they functional?
It's functional.
You haven't said anything about it in your compliance.
Kindly, my lords, my compliance affidavit would, my lords, throw light as to the details, my lords. 18/2/2022, I have filed my compliance affidavit. Kindly, my lords, notification dated 23/10/2019 is produced. Paragraph number 3 in my compliance affidavit are stated. In compliance of oversight, my state government has issued notification dated 23/10/2019, indicating designated courts in each district for accomplishing the objective and purpose of the Rights of Persons with Disability Act 2016. In the said notification, it is clarified that public prosecutors performing the duties in the designated courts shall be special government advocates for discharging the duties and obligations for and on behalf of the state government for accomplishing the objectives and purposes of the Right of Persons with Disability Act 2016. Copy of the notification is produced. The notification, my lords, is at page number 5. Page number 4 is the copy. Page number 5 is the translated copy.
Appear for the petitioner.
Vishwesh?
The rules have not been framed. Whether the rules have been framed.
Framed, my lords. Rules have been framed and rules have been notified in the Gazette. He is also notified in the e-Gazette. And my lords, there are complaints.
Mental health care rules have been notified.
Please.
What about mental health authority notification of?
That's been done, madam. It was done 18/10/2021.
Have you filed any compliance, Mr. Rajshekar?
I have 5 minutes. E-filing is done. Copy is also served on the other side. But ODP could not be generated on Saturday.
Public interest litigation was filed in the year 2019 seeking following relief. Mr. Rajshekar, learned AGA, appearing for the respondents on the basis of inspection submit that the relief claimed in the writ petition no more survives. it is submitted that the by notification 23rd of October 2019, the designated court in each district have been notified for accomplishing the object and purpose of the Rights of Persons with Disability Act 2016. It is also submitted that the state government has notified the state mental health care rules. Full stop.
Notified on 30/10/2020.
The respondents have set up and notified the state mental health authority under section 45 of Mental Health Care Act 2017. In view of above, we are of the view that nothing remains to be adjudicated in the instant writ petition, which is accordingly disposed of.
One submission, my lord. My name may not be shown, my lord.
In the beginning, right, Srimati Ravati Ajitnath Nare, advocate, informs that she is not appearing in this matter. Under the Rights of Persons with Disability Act.
Obliged, my lord.
Number 8, Gangadhar GD.
Respondent 5/19.
Is a petitioner, my lord, the petitioner grievances, my lord, that is the Gomar land, my lord. That is the village, Halreli village and the Virapur village, my lord. That is reserved for the Gomar lands, my lord. For the free pasturage of the cattle, my lord. The applicants, my lord, before this honorable court, they are the unauthorized occupants, my lord. Even though their applications filed under form number 57, my lord, they have been rejected, my lord. Without challenging that application, they have approached this honorable court, my lord, for regularization of those applications, my lord. That is one aspect, my lord. And the second aspect, my lord, that they have filed an affidavit before the authorities stating that they are landless and sightless persons, my lord. Even though they are having sufficient agricultural lands and properties standing in their family members' name, my lord, all the applicants who have filed the applicants before this honorable court, my lord.
What has been done till now? Is there any order passed by this court in your favor?
Let's comply status. Well, let's all these applications which were made under form number 57, my lord. Only 7 applications were found eligible. All applications have been rejected. Those 7 applications were placed before the committee, and committee may not choose to take a decision on the matter. I have filed my compliance affidavit on 31.
What happened to 7 applications?
It is before the committee, my lord. That is, committee is not yet constituted. That is only as and when the committee, my lord, gets constituted, those applications will be decided.
My lord, earlier, my lord, that is in page number 18, my lord, and that is dated 30/12/2021. Before the Bagarukum committee, my lord, all these applicants, all these 40 applications have been rejected, my lord. Even though the learned the government advocate which is making submission with respect to 7 applications, my lord, even though those 7 applications also have been rejected, my lord. In the year 2002 itself, it has been rejected, my lord. Without challenging that applications, my lord, they have approved this honorable court, my lord.
And they have constructed the huts and other things, my lord, near the lake tank beds, my lord. And they say that when the rain comes, all the floods and other things will enter inside the huts, and they will not be having any place for their residential purposes, my lord.
This public interest litigation was filed.
One more submission.
One more submission. Shall I submit, madam? Notes respondent number 5 to 19 are stating that they are the grantees of the site. Notes it is situated on AK column. Notes due to heavy rainfall, mallards during these years, mallards, the entire village, mallards, half of the village has been submerged. Mallards, only relief claimed by the applicants is that, mallards, this Goma land, where the Tahsildar has stated that they have identified 5 acres of land to shift this entire AK colony to this land, mallards. Mallards, if the eligible applicants are there, mallards, let them allot a site. The persons who have been eligible in the AK colony, mallards, whose house has been demolished, mallards.
Seeking following relief. Third, the counsel for the petitioner as well as the AG appearing for respondent number
1 minute.
1 minute.
respondent number 1.
Respondent 1, 2, 3. All the respondents, 1 to 3.
For the respondents, you appear for
5 to 19, mallards. 1 to 4 new.
as well as counsel for respondent number 5 to 19. Then it AGA on the basis of instructions. You have filed a statement of objection
Please, ma'am.
as well as a statement of objection submit
Dated 6/8/2020.
that only 7 applications have been found eligible for allotment. However, all these 7 applications are to be considered by the committee constituted by the state government. However, the said committee has not yet been constituted, and as such, there is no question of any allotment of land in favor of any person. The apprehension of the petitioner is totally misconceived. Parallel counsel for petitioner, on the other hand, submits that the Goma land is required to be preserved for posturing, and the persons who are in possession of the Goma land are using it for cultivation. Full stop. The respondents are not taking any action to preserve the said government land for fostering purpose. Be that as it may, it is for the respondents 1 to 4 to take appropriate steps to preserve the government land. It would be appropriate that the grievance of the petitioner is considered by the concerning authority, maybe respondent number 2, Deputy Commissioner.
Yes, fellow, please.
For the
In view of above, the writ petition is finally disposed of with observation that the grievance of the petitioner as set out in representation dated
19, my lord. And annexure F and G, my lord.
annexures F and G.
My lord.
give the date
Dated
2019, my lord.
12/12/2019.
Marked annexure F and G, my
Annexure
lord.
number
F and G.
F and G is considered and decided in accordance with law and appropriate orders are passed expeditiously, say within a period of 4 months from the date certified from the date copy of the order is produced. A long copy of representation produced before us.
My lords, in respect of respondent number 5 to 19, my lords, other applicants, my lords, let the deputy commissioner also take action, my lord.
We have not said anything on merit.
Number 9.
Much obliged.
Challenge is annexure A. I, the Director of Mines and Geology, who is an authority, not an authority to consider under Section 10 of the MMDR Act, refusing to extend the period of the lease, during which the petitioner is not permitted to conduct the mining operations. The issue that falls for your consideration, whether the state government, having prevented the petitioner from exercising the concession under the leasehold rights, refused to extend the period of the lease during which time where the petitioner is prevented. On 14/8/1979, the mining lease was granted to the petitioner. When the lease was in subsistence, the Honorable Supreme Court of India in T.N. Godavarman passed an order that unless in case of forest lands obtain the permission under Section 2, they should be prevented from conducting mining operations. And accordingly, on 25th of January 1997, Annexure K, the petitioner was instructed to stop the mining operation till the petitioner obtains permission under Section 2 of the Forest Conservation Act. By that time, the period of the lease expired. The petitioner filed an application for grant renewal of the lease.
Who are you?
I am the lessee. Having been granted a lease, and I am prevented from conducting the mining operation. Now the period of the respondents are stating that my period of lease is over. Therefore, I am not entitled to under Section 8A6 of the MMDR Act as amended by Act number 10 of 2015.
This case is for extension of lease.
It's the period in which you took to get the permission under section 2 that you want to.
Yes, that's 1 minute. That's from 97 to 2055 minute. Because of the order of the Supreme Court, I am not permitted to operate. Minute Annexure X minute on 9/11/2005, a notification was issued minute renewing this mining lease in favor of the petition, subject to obtaining permission under section 2. I obtained a permission under section 2 of the Forest Conservation Act, and the Government of India and the Government of Karnataka permitted this millet on receipt of 2.81 crore millet as the NPV millet. And after receiving the permission under section 2 millet, and after
When was that
entering,
permission?
yes, sir.
When was the permission received?
The permission is granted millet. It is on millet, the 9/3/2007. But thereafter, millet, this lease was executed, renewing the lease millet on 8th April 2007. Millet, Annexure AC, page 239. Millet. Page 239 minute, volume 1 minute. April 2007. Your Lordship got? Yes. Then minute, immediately minute, the Director of Mines and Geology issues a notice to the petitioners alleging that minute, the renewal itself is illegal and stops the mining operations. That order, your Lordships, get at page 309, that is on 24/4/2008, Annexure A. English translation is at 311. The substance of this notice is that the renewal granted itself is void, and therefore I was instructed to stop the mining operations, and I was also directed show cause why the lease shall not renewed. Application for renewal shall not be rejected. Let Annexure AF. But against this revision, I filed a revision before the central government, which is a revisional authority. But the revisional authority granted an interim order, which is at page 366, 336. And this notice is served on the ground that application has already been disposed of, granting the mining lease. The state government could not have issued a notice under Rule 26(1), proposing to reject that application which has already been disposed of. This interim order, during this interim order, which is filed on 11/9/2008, and thereafter he was permitted to conduct mining operations. The central government rejects this on 30/11/2010, Annexure AJ, page 346. Upholding the notice issued to the petition.
Revision was rejected.
Revision was rejected, stating that it granted by. But against the order of the central government, the petitioner filed the High Court, have approached the High Court of Delhi by filing writ petition 2355 of 2011. It is in volume 2. Before the High Court of Delhi, an objection was raised by the state government, stating that Delhi High Court has no jurisdiction, even though the order is passed by the central government. Karnataka High Court is the competent. Accordingly, the petitioner withdrew that writ petition. Your Lordships get that order at page 514. That respondent in counter affidavit had taken objections with regard to territorial jurisdiction. The respondent contended that the jurisdiction would lie with the High Court of Karnataka. The learned counsel for the petitioner seeks to withdraw the petition with liberty to file fresh petition before the appropriate jurisdictional court, so and so. My lord, then I came before this court, my lord, filed WP 18,792 of 2017, which your lordship get next page 515, my lord. My lord, this court allowed the writ petition, found that, my lord, the order of the state government is bad, that your lordship get page 563, my lord. I'll just read this out. By filing this writ petition, decision taken by the revision authority under Mines and Mineral Development Regulation has been impugned. They appreciate the rival contention. We need to look into the facts for our benefit. On August 14, 1979, lease was executed in favor of the writ petitioner for a period of 20 years for extraction of the iron ore mineral manganese ore, which was valid up to 13th August 99. It was incumbent on the lessee to make an application for renewal of the lease before the expiry of the lease. In fact, February 11, 1998, that is long before the expiry period of the lease, the application for renewal was filed by the writ petition, but it was filed in the wrong counter, that is, in the office of the Deputy Conservator of Forests, instead in place of Director of Mines and Geology, which is the appropriate authority. That I am reading page 566. Well, it only. Pleadings completed, Millet. I also filed rejoinder, Millet. Any one of the days convenient to the court, Millet, I will.
Lord, they have filed contempt proceedings, Lord. If they are taking time, Lord, let them not precipitate the contempt. Contempt is coming up on Friday.
They filed the application before the Honorable Supreme Court. Millet. Supreme Court initially granted it. Very well, but I'll take time in that contempt also. That is with regard to prior to March 2020. Despite the order of your lordship, they defined.
If some interim orders or some arrangement has to be made,
Please.
but it appears that it has to be finally heard.
Short question for consideration is that, Lord, it cannot be extended beyond 50 years. The initial lease is in the year 1959. Now they are seeking lease beyond 50 years. We have extended up to 31/3/2020 as contemplated under sub-rule 6 of rule. Section.
We'll have to determine
Computation of the period of the lease.
for that 20 years in between.
Millet, is the period prevented? It's part of that, Millet, is part of the computation of the period of the lease. Can the lessor, it is a lease under the Transfer of Property Act, under 105 of the Act, also Millet, Transfer of Property Act, MMDR Act is applicable. If the lessee is prevented, Millet, by the respondents on their own, can that period be considered is a question before lordship?
That is covered by the judgment of this Honorable Court in Shanti Priya, WP 505456. I'll produce it. Covered.
Both the councils submit that the pleadings are completed and the matter would have to be taken up for final hearing. We list.
Please. Number 10.
Lords, in 10, I represent as the amicus curiae, my lords. On the last date of hearing, the lordships had directed BBMP to file its statement of objections relating to, lords, the solid waste management rules, implementation of it, my lords. Lordship would refer to 16/11/2021 order and 8/12/2021 order.
You have carried out the fiscal amendment.
Yes, my lords, we have carried out, we have served copies also on the council for BBMP. The amendment is the memo along with the past.
Yes, I have received the copies.
Yes.
But now they are undertaking the inspection. Just to be completed, my lord, I'll request for another 2 weeks' time. We will file a report. It's a vast area. Bomsandra industrial area.
Bomsandra industrial area.
Yes, my lord. It's a very vast area, my lord. We need some more time to complete the inspection. In fact, my lord, Pollution Control Board itself has given a status report indicating the earlier petitioner himself violated, themselves violated. As such, they moved an application, or they wanted the petition to be disposed of. This honorable court thought it fit, my lord, that it has to be heard suo motu. That's how, my lord, this proceedings are continued.
The issue would be relevant because there are a lot of industries in the area, whether they are actually implementing these policies. That's the only issue. If BBMP can give us a report or file its objections, my lords.
As regards disposal of the waste, my lords, we will definitely give a status report. As regards the foul smell order, my lords, that Pollution Control Board has to conduct a investigation and then file its report, my lords. The notices issued are well not.
Mr. Srinidhi, now counsel appearing for second respondent place for is allowed 2 weeks' time to get the inspection completed by the BBMP.
Yes, sir.
Give a date after 2 weeks.
10th March.
Obliged.
Number 11. That I appear for the petitioners in these matters. Annexure A, cancelling the entire tender process. That under the amended rules is before your lordships, Chapter 4A provides for grant of mining lease for tender cum auction.
In some of them you filed amendment applications.
Yes, in 2 I have filed amendment application, and in others, in 4 cases I have filed rejoinder. All of them will be applicable to the same. In this case,
Any objection to this amendment application, Mr. Mayor? 11.2, 11.2, 11.3. Counsel for the petitioner has filed IA-1 of 2021 and IA-2 of 2021 for amendment of prayer in the writ petition, accepting the reasons stated in support of the affidavit. In IA-1 of 2021 and IA-2 of 2021, the said amendment is allowed, and counsel for the petitioner is directed to carry out necessary amendment and file amended writ petition after service to the counsel. What about this dispensation?
Dispensation of annexure A.
All dispensation applications are allowed.
Please.
Any additional objections you want to file, Mr. Mahendra? Shri S.S. Mahendra, where an AGS seeks for 3 weeks, 6 point is granted 3 weeks time to file additional objections in view of the amendments. The list.
25-3.
That I appear for the petition. That is a pattadar of the land. Petitioner is a pattadar of survey number, is owner of the land. Survey number 188, Honaganadi village. He made an application for grant of quarrying license under rule, the KMMC rules. The quarrying license is granted. Your lordship kindly come to page annexure yes, page 113. 1089 is granted on 28/12/2020.
Yes.
Correct. Annexure, yes, page 113, my lord.
Question is that you have found
Correct.
blasting.
They issued notice, your lordship, I kindly say annexure T, my lord, the notice.
Annexure?
Annexure T is the show cause notice, page 135, my lord. The allegation is, my lord, that I have conducted the quarrying operation by using the blasting materials as there is a tank within 50 meters is the show cause notice, my lord. Kindly see the show cause notice, my lord.
Yes.
Yeah. With reference to the above subject, Deputy Commissioner, Mandya District formed a mobile squad to control the illegal minor quarry operations, transportation in Pandavapura Taluk, Mandya District. As per the above, on 27/2021, at the time of beat by the Revenue and Gram Panchayat official staff, the police station of Chinnakurdi officials of the Department of Mines and Geology visited your QL number 1089, granted to you in 188 measuring 3 acres, Vanaganadi village, Pandavapura Taluk. Thereby notice that there is a pond in the existing in the for conducting quarrying operation earlier, and in the wall pond, there is a mark of conducting of blasting, and technical officials have submitted a report stating that to get the report from the concerned officials in order to take a legal action by the technical officials under the Explosives Act for conduct of quarrying operation and using blasting material. In the condition of the license book, directed that use of low density blasting materials. In addition, condition as per Rule 6(2) of the KMMC rules to conduct quarrying operation by hand living 50 meters from the pond. 50 meters from the quarry, there are public structures. There are permission is granted to conduct quarrying operation without using blasting material. This official, this office, a technical officer, have informed that there is a mining the pond in the said area. In the pond, there is a mark of blasting. The same is violation of Rule 6. Therefore, you are directed informed to give your explanation why your quarry shall not be cancelled within 3 days from the date of the receipt of this letter, failing which further action will be taken. My lord, I replied, my lord, on 37/2021, next page, my lord, 139. My lord, without even hearing me, my lord, this order is passed cancelling the quarrying license granted, which is not even part of the show cause notice, my lord. The show cause notice is, my lord, that I am conducting quarrying operation using blasting materials in the pond which is about 50 meters. My lord, I have filed rejoinder. Your lordship may kindly come back to page 116, my lord. The sketch, my lord. Kindly see the sketch, my lord. Yes, this is 188 is there, my lord. In between there is a survey number 127, my lord. My lord, this is the tank is thereafter, my lord, is more than 150 meters. My lord, after this, my lord, along with the rejoinder, my lord, I have produced the documents. I made an application to the Tahsildar to give a report of the distance from the quarry lease to the quarrying license to the tank, my lord. Annexure V, page 5, my lord, along with the rejoinder. Sketch is, my lord, at page 7, my lord. The Karnataka surveyor has given a report saying that, my lord, it is 150 meters. Your lordship, rejoinder, your lordship.
Yes.
Rejoinder, it is at page 7 of the sketch, my lord.
7.
Yes.
Page 7 is with regard to para 1 and 2.
No, my lord, this is no, my lord, this is the annexure B, my lord. Along with the rejoinder.
Mr. V.
I'm sorry, my lord. There is an application filed, my lord. Yes, there is. It is at page 15, my lord.
Annexure V1.
Yes. V1, rejoinder. Last at the end, your lordships will kindly see, my lord. The distance is, my lord, is 120 meters, 150 meters, my lord. But in identical cases, my lord, this court, my lord, the procedure under rule 6.3 has to be followed, my lord. So they have to give a notice, my lord, they have to hear me, they have to call upon me to rectify the defects, if any. My lord, if I don't rectify, they have to impose a penalty. And thereafter, my lord, then they have to take a steps for cancellation.
Yes, what do you say?
Annexure X is the order of this
Whether the
honorable court.
procedure prescribed under 63 is to be followed.
We have followed all those procedures.
You have followed.
Yes, we have followed the procedure. The last may kindly see, prior to the execution of lease license, he has conducted illegal mining, and we have imposed a penalty of rupees 3,44,72,500. He has admitted the guilt and sought for 3 installments to pay the penalty imposed. In pursuance of the same, he has paid rupees 25 lakh. The last may kindly come to page number 39. 39 is the order, impugned order.
That is not part of the show cause notice, my lord. Because earlier revision petition was filed, my lord.
When you were arguing, he did not.
Please, please.
The last may kindly see the operative portion of the order. I, senior geologist, Department of Mines and Geology, Mandya District, in exercise of powers conferred under Karnataka Mine and Mineral Concession Rules 1994, cancel the quarry lease number so and so. Karnataka Mine and Mineral Rules 1994 for 98,493 metric ton directed to pay penalty of rupees 3 crores so and so. In the said penalty, 25 lakh is paid and directed to pay balance of rupees and directed not to conduct any quarrying mining activities in the said area illegally, failing which suitable legal action will be taken. But on an earlier occasion on the same order, he preferred a revision. Now, he bypassing the revision, he has preferred this writ petition. There is an alternative remedy against this order. Now he is contending the pond is not within the distance of 50 meter, it is in the distance of 100. These are all the disputed facts which has to be looked into by the authorities. Prior to passing this order, we have issued a show cause notice. He has replied to it. Upon considering all the aspects of the matter, Lord, this impugned order produced at annexure came to be passed.
After his reply, was he heard is the question. So he issued the show cause notice, he has replied.
Yes.
Only question is whether he was heard
or not.
Personal hearing was not there.
That would have to be given.
Personal hearing is not.
We give him a hearing and he'll be satisfied.
Provided she shall deposit the admitted amount. Because it is his own say. Your last may kindly come to.
His admitted amount, Mr. Chairman.
No, 109. 109, your last may kindly. There is.
I have not conducted any.
Annexure R 109. Page 109, annexure R.
109.
And translation is at 111. Relevant portion is at 112, page number.
Where is the admitted amount?
Admitted amount is not in
page 110.
the Kannada version, it is there. Read it. He says not.
25 lakhs.
So admitting that he has paid 25 lakhs through DD, and he sought for other 2 installments to pay the remaining amount, balance amount. And requested you to grant time to pay the said amount in 3 installments. And for the first installment, a sum of rupees 25,000 has been paid. And for remaining in 2 installments, he has to pay, he has not paid.
Mahendra, at annexure Q, he says that the amount is 68,94,000. Where is he admitted 3 crore 44 lakhs, that's what you say?
Not in Kannada, may I read, in annexure R 109. Other in the bottom 4 lines, other in the Tavu Tilisiruva 98,493 metric ton ಗಳಿಗೆ 1 ಪಟ್ಟು ದಂಡವನ್ನು ಪಾವತಿಸಲಿಸಿದ್ದರಿತ್ತು. ಸದರಿ ಮೊತ್ತವನ್ನು ನಾನು 3 ಕಂತುಗಳಲ್ಲಿ ಪಾವತಿಸಲು ತಾವು ಕಾಲಾವಕಾಶ ನೀಡಬೇಕೆಂದು ಕೋರುತ್ತಾ ಮೊದಲ ಕಂತಾಗಿ 25 ಲ್ಯಾಕ್ಗಳನ್ನು ಡಿಡಿ ಮೂಲಕ ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸುತ್ತಾ ಕಲ್ಲು ಗಣಿಗಳನ್ನು ಮಂಜೂರು ಮಾಡಲು.
Where the notice dated 11/12/2020?
11/12.
It is at page 102.
102.
104 is the translation.
Translated.
102, it is there, Mr.
Yes, against this, Milad, revision was filed, Milad. The revision authority found, Milad, this is underground deposit, Milad. 5 to 6 feet of waste mud was there, Milad.
There are only 2 issues, Mr.
Yes.
One is your hearing. That is agreed that his only contention is that the admitted amount has to be paid. 102, the demand was made for 3 crore 44 lakh 72,556. 110, you agreed to pay 3 installments, 25 lakhs you paid.
In fact, in the said notice, Milad, I have said clearly, Milad, if you take 70 rupees, Milad, that is, Milad, a very appreciated amount has been claimed by them, Milad. I have said, Milad, if taken into consideration, it comes to 68,94,510, of which I will pay 25 lakhs, Milad.
Right.
They have received 25 lakhs, Milad. Annexure Q, page 106, Milad.
Yes, but in annexure R, you haven't said that.
Yes, that is the notice on which basis, Milad, I have paid 25 lakhs.
You'll have to deposit it.
Milad,
you can't have the best of both worlds.
Milad,
All that would be subject to decision.
Milad, I have, in fact, Milad, if they take into consideration 98 lakh 740, Milad, if they take 70 rupees, Milad, that was the royalty. It comes to
deposit, we'll ask them to consider, give you a hearing.
The balance of this, Milad, as per my letter, Milad, 68 lakh 94,510. That is the one I have admitted to pay. The balance I will deposit. 25 lakhs I have already paid.
Then you refer to the notice of 11/12 and say you will pay it.
Yes.
You will reduce the amount there.
Millet, I'll just take your lordship the revisional order, Millet. On this basis, Millet, the quarrying lease was not executed. Millet, your lordship may say 25 lakhs subject to deposit of 20 lakhs, 25 lakhs, let them hear. If there is anything payable, Millet, let them.
There is 2.7 crores, Mr.
Millet, this is true. Millet, it is, if your lordship could see, Millet, it is 68 lakh 94,000 I have admitted. I said I will pay. The reason is, Millet, because of the order of the revisional authority, Millet, which is binding on them annexure L, Millet. On the basis of this notice, Millet, quarrying license was not executed. I approached the revisional authority. Revisional authority passed an order. It is at page 95, Millet. It is on the basis of that notice. It is not that, Millet, I have not challenged it, Millet, challenged before the revisional authority. Joint director in exercise of power conferred and so and so. Direct the take action as per Karnataka list, amendment so and so.
So it will be subject to that.
Yes.
The deposit that you make will be subject to that.
Right now, the quarrying operation is stopped, Millet. He will not be able to raise so much, Millet. Therefore, your lordship may direct him to pay 25 lakh rupees, Millet. It will become 50 lakhs.
This amount is quantified because of the illegal activities conducted by him.
Millet, your lordships will kindly see, Millet, the why that this thing is I have given in my letter, Millet.
Because you are not willing to deposit, then on that ground only your writ petition will go. Because you already violated.
Millet, I have
you can only consider doing that, asking him that if you deposit it.
But if you don't agree, then this petition will not.
Can that be?
The deposit, we do not know, Millet, what they will ultimately do it, Millet. Because it will be very
subject to the result.
Your lordship, may I pray your lordship, 25 lakh would be reasonable, Millet. I will speak. Admitted amount is 68 lakhs.
No, not in these matters. Them to give you a hearing.
Like just may I take instructions, Millet?
Instructions are just sitting. You take the instructions.
Yes.
The petitioner is before this court seeking for the following reviews. The reasons of the petitioner
Just
is
before that, Millet, may I just read your lordship one judgment of your lordship, Millet?
the grievance of the petitioner.
Rule
is that
6.3 is not followed.
though show cause notice dated 27/2021 has been issued, alleging certain violations of the mining lease granted in favor of the petitioner, and the petitioner has replied to the same by his reply dated 31/7/2021. The impugned order at Annexure A has been passed
On the same day on the ground, I have not filed objections.
31/7/2021 without affording a opportunity of hearing to the petitioner, and on the ground that an earlier penalty which had been levied has not been paid in full. In that, the earlier penalty of 3,44,72,550, which had been levied, a sum of rupees 25,00,000,000 had been paid, leaving a balance of 3,19,72,550. L.M. Chidananda, learned counsel for the petitioner, would submit that without granting an opportunity of hearing, no such order could have been passed, more so when there was a reply which was already on record, which has also not been considered. For contrast, S.S. Mahindra, learned counsel, learned AGA, appearing for the respondent, would submit that the petitioner had in his letter dated
Annexure
Annexure N, page 99.
18/12/2020 had admitted the liability to make payment of the penalty amount, though seeking for 3 installments for such payment, and has remitted a sum of rupees 25,00,000,000. The balance has not been paid. If the balance amount is paid, the respondent would provide an opportunity for hearing, considering that the violation of non-payment of the penalty itself is a ground enough for cancellation of the lease. Third, Shri L. M. Chidananda, learned counsel for the petitioner, Shri S. S. Mahindra, learned AGA for the respondent. The title of the document indicates that in response to the so-called notice, penalty notice dated 11/12/2020.
Just one.
Wherein
Notice
a
doesn't
sum of-
mention penalty. It is only violation of Route 6(2), my lord, annexure T, page 135.
We are referring to Annexure P, Mr.
Please.
Please. 11/12/2020 at Annexure P, a penalty of rupees 3,44,72, 550 had been imposed. In response thereto, the petitioner had, while his letter dated 18/12/2020, requested for a resurvey of the property and also indicated that they would make payment of penalty for 98,493 metric tons in 3 installments and enclose the first installment of rupees 25,00,000,000 and requested the respondent to grant the quarry lease. It is of importance to note that this set of correspondence occurred even prior to the grant of quarry lease on 28/12/2020. That is to say, the petitioner had carried out quarrying activities even prior to a quarrying lease having been executed in favor of the petitioner. In view of the same, the submission made by Shri S. S. Mahindra, learned AGA, deserves merit and consideration. In the event of the petitioner depositing the penalty already levied, which has been conferred in the revision petition already filed, the respondents are directed to afford an opportunity of hearing to the petitioner in respect of the so-called notice dated
Annexure, my lord, Shokas notice dated 27/2021.
27/2021,
Annexure T.
27 what month? 20th July 2021.
Yes.
And thereafter pass orders on the said so-called notice.
Revision is not pending. They have to file a revision.
No, the earlier one they have filed
Earlier
a revision,
revision.
that was disposed of.
That was discussed.
Earlier revision, my lord, that penalty imposed has been rejected by the jurisdictional authority.
No, it's not been rejected.
That is true.
It's not been rejected.
No, in fact, your lordship could see annexure L, my lord,
We
page.
just read it when you pointed out, Mr.
Yes.
It does not.
No, on the ground, my lord, this because of the penalty, my lord. My case was, my lord, I have removed only the waste mud and put the waste mud on the side, expose the building
You
stone.
reply to this.
Please.
Number 13, Dinesh Rao.
Annexure A has to be passed, my lord, again they will use. Annexure A has to be passed, my lord, so that they can consider.
Payments, if any, to be made within 4 weeks of the receipt of this order. If the said payment is made, Annexure A shall stand quashed and respondent shall provide an opportunity for hearing.
Please.
Number 13,
The issue relates to royalty, my lord. The petitioner is a construction company and has been constructing a market under smart
These
city
are
project.
covered, Mr. Mahindra, by the other
Please, my
matter.
lord. It's covered by the judgment, my lord.
It is not.
Additional royalty.
Royalty of the construction company.
No, their case is not. The respondent number 2 and 3 is not supposed to deduct royalty from the bills raised. But primarily the petitioners have not reduced MDPs for having transported the minerals to the for the minerals consumed for the project.
So it won't be covered under the
Failure on their part to produce the MDP. They are liable to pay royalty, which is to be deducted from the bills raised on behalf of the contract.
In fact, we have stated so in our objections. We are the contractor. We have stated that if there is sufficient documentary evidence shown to show that royalty has been discharged, then my lords, we are not obligated to deduct. But in the absence of those documents, and also, if I may make one more submission, in essence, what they are asking in this petition is that there is a contracted sum of, say, X amount. You have paid X minus Y. Now, please refund that Y. It's a classic money recovery suit. It's a pure contractual dispute between me and the petitioner. Of course, we have deducted that amount and deposited it with the department. So therefore, the department also is a party. And if they were to file a suit to recover those amounts, I'll have defenses available before the civil court. Because for 2.5 years, without any demur, they've accepted the payments. That is minus the royalty amount. So section 63, estoppel, so many defenses I'll have before the civil court.
May I pass on the judgment of this honorable court, my lord, wherein the same issue has been discussed and it has been clearly categorically held, my lord. They can examine that part, whether the gravel which I am using has already suffered the royalty. Because prima facie, the payment of royalty is the duty of the person of the leaseholder. Whereas here in the instant case, my lord, I am not using even gravel. I am using ready mix. So therefore, the question has to be examined by them. They can't just drive me to civil court. And this is the question, the very same issue.
You use the gravel, convert it into ready mix, and then say,
I am not using it. I am the person, I am a contractor, my lord. I am getting it from the cement company.
So where is the MDP where it shows that some royalty has to be paid by somebody?
That is the duty of the leaseholder, my lord. They will have to manage. They will have to check with him.
You are the person supplying.
I am buying it from the open market, my lord. This is precisely what the coordinate bench has held, my lord. If I can demonstrate that I am buying it from the open market, I am not a leaseholder. It is the duty of the prima facie duty of the leaseholder to pay the royalty. I am the end user.
You are the one asking for no deduction.
Please,
so you have to satisfy the requirement.
Because the prima facie very demand, even deduction itself is illegal. Because the duty of paying royalties with the leaseholder and not with me. Fairly covers, my lord. Very same issue. The Lord may kindly turn to page 5, my lord. C. Where the contractor uses material purchased in open market. That is material purchased from private sources like quarry leaseholders or private quarry owners. There is no liability on the contract to pay any royalty charges. So they will have to show that I have extracted the material from the leased land. When there is no liability, prima facie liability, why should I be driven to civil court, my lord? The very deduction itself is illegal.
I've seen this, Mr.
I've seen the judgment. There also, my lords, if my lords may kindly see paragraph C, where the contractor uses material purchased in the open market, that is material purchased from private sources like quarry leaseholders or private quarry owners, there's no liability. All we're asking for, my lords, is to show that when you have purchased it from these private quarry lease owners, show us some proof that that has suffered royalty. Because very often, my lords, what happens is they are...
Let them ask. I will definitely furnish. Let them ask, my lord, because
that is going
now,
forward.
As per this particular judgment, my lord, I am not liable to pay.
If you
They will not examine my issue, my lord. They will not examine my issue in the light of the...
Mr. Rao, it's your contention that you have bought it from the open market.
Please,
so you have to establish something that you have bought it from. We don't know where you have
Can you
purchased.
show that you have purchased?
I will do it, my lord, but let them examine it before deducting the...
No. It is you who have to first establish that you have...
No, as per this judgment, my
from the
lord.
open market. It is not for them to first examine.
No, Annexure C is very clear, my lord. The moment I buy it from the open market, and here I use it from the ready mix, my lord, not even from the open market.
Where is to show that you have purchased it from open market? Any document to show that?
It is the burden on the petitioner
You cannot be presumed. You will have to establish first. Kindly show.
Royal,
In case if I satisfy, let them not deduct, my lord.
No. It is not that.
No, this particular judgment, my lord, it clearly says.
It does not say that it all is to be established by them.
No, with great respect, my lord, it says that, my lord, there is no liability on the contract to pay. Page number 5, my lord, C. It can be even vice versa.
Only when you establish that. First show that you have procured it from the open market.
Your lordship, kindly see, my lord. In case, next, my lord, D. In cases covered by paras B and C, the department cannot recover or deduct any royalty from bills.
Correct. There's no doubt. First show that you have done it from the open market.
Please, my lord.
not only he has purchased from the open market, he has purchased the minerals which has suffered royalty. That he has to establish.
Yes. From the open market.
Oh,
means
yes.
that it has.
The lordship kindly observe that in case if I satisfy these conditions, my lord, they are bound to refund.
First show to us. Is there anything on record to show that?
Please, my lord, your lordship kindly grant me 2 weeks' time, I'll produce.
After arguing the matter for some time, the Learned Counsel for the petitioner seeks for 2 weeks' time to produce documents. Weeks' time to produce documents.
2 weeks' time may be granted.
No, will not. 1 week is good enough.
No, because I'll not get information from Belgaum, my lord.
So what?
Then I'll not get it from the cement company, and in turn, cement company has to get it from the leaseholder, my lord. That's
So
the
that he has
problem.
purchased the mineral from third-party open market, and that the same has already suffered royalty.
2 weeks, my lord.
13, no?
In March. Number 14.
Senior Counsel Samin Jaiswal is appearing.
I beg to appear in this matter. I am logged in. If your lordship sees, your lordships on 20th of January have passed a very detailed order. And your lordships had in that order, the last paragraph, granted 4 weeks' time to the AG to file objections. Earlier also, your lordship had passed an order and your lordships had directed them to file a report or whatever status report regarding the invest. They have, my lords, frozen all our accounts. They passed an order under Section 3. Our contention is that we are not a financial establishment. And to that effect, my lords, your lordship has noted down my contentions in support of the same.
Yes.
And I think for 3 more weeks, Lord. The validity of the provisions have been questioned.
2 weeks.
3 more weeks.
But it is for the not 3 weeks for the time to file the statement of objection. Give a date.
21/3.
Is the next date of listing? The interim order.
Friday, my lords, 25th.
25th.
Yes, my lords. Because I'm hoping by that time everything will become physical and then.
All right, 25th.
Please, my lord. Okay.
Number 15.
Before your lordship, very short comparison. I approached the learned single judge seeking for a direction to consider my representation, which came to be dismissed. The facts relating to the case were that the land originally stood converted in the year 1970.
Mahendra, you have to get back to us on Annexure A. Any action taken?
Lordship's last occasion and directed to tell if any action.
Action taken by the state subsequent to the decision of KIT at Annexure A.
Please.
Who is appearing?
Ashik Mishra.
Last time you had appeared.
Reconstruction.
My instructions are that as of today, nothing has progressed. It's only the clerical formal deletion of the entry in the revenue record pursuant to the order. Let them examine.
Yes, Rajshekar learned AGI. And is granted 2 weeks time to make a submission on the action taken by the state subsequent to the decision of the Karnataka Appellate Tribunal under Annexure A dated 23/8/2019.
May I proceed? Appellant number 3 is hospitalized. His leg is also amputated. May I request for 1 week? The appellant number 3 is on his deathbed. His leg is also amputated.
1 week.
Please for consideration.
14 March.
I'm so grateful.
Number 16.
Pleasure.
Badrinath.
But sorry, I appear for the respondent number 8 in this matter.
I pay for the appellant.
Respondent number 5 in the matter.
Just before the bench of which one of us write the name of the do not remember. After offering this the order on the administrative side by
Number 17. Amit.
I appear for the petitioner in this matter, my lords. I challenged, my lords, the validity of amendment to the Bangalore Water Supply Sewerage Regulations. My lords, I sincerely apologize. There was a inadvertent error in my prayer, my lords. On the last occasion, I filed a suitable amendment. Instead of seeking a declaratory relief, I sought for a certiorari. And therefore, my lords, I am now filed an amendment application as well, my lords, seeking to modify that prayer A, my lords. Prayer 2, sorry.
the fearful only.
And I appeal for the state, no?
Hmm.
I appeal for the state, no?
Do you have any objection to the amendment application?
No, no, it's not India. It's only in relation to the prayer.
On the IA2 of 2022, the counsel for the petitioner applicant submits that the application has been filed seeking amendment seeking amendment in the writ petition by inserting relevant paragraph regulation number 5.
Yes, my lords. Regulation number 5, my lords.
As well as seeking a relief for declaration of Regulation 5 of Bangalore Water Supply Amendment Regulation 2015 as amended by notification dated 25th of February 2016 as ultra vires to the Constitution of India. No objection has been filed. Learned AGA submits that he has no objection. The application is allowed. The counsel for the petitioner is permitted to carry out necessary amendment in the body of the petition as proposed in the application within a period of 1 week from today and file the amended copy of the petition after giving notice to the other side.
Plus, may I seek a short date because I've sought for some interim relief members.
Give a date.
8-3. Great members.
Chamber 18. Purnima Hatti.
Your Lordship, I am appearing for the petition on this matter. Your Lordship, we are ready for arguments. If we will require at least 1 hour to complete arguments, so if your Lordship pleases, kindly post a case on a suitable date for completion of final arguments.
Our counsel for petitioner seeks a short explanation to argue the matter suspended. On his request, adjourn list on
25th March.
Much obliged, Your Lordship.
Again, no date.
7th April. Number 19.
For petition, my lord. It is subject matter is for the consideration for my lord annexed A, shifting of primary health center from my village to another village. On last date of hearing, your lordship has directed to file affidavit. Now they have changed their decision with respect to not to shift the primary health center from my village.
So relief won't survive.
Yes, ma'am.
You're not.
They don't want to shift my primary health center from our village.
You are not shifting primary health center now. The petition has been filed. The nature of public interest litigation.
On last day.
The learned is AGA. You filed statement of
Yes, ma'am. Affidavit is
informed
filed on
that affidavit
7th
has been
January.
filed
On 7th January 2021.
7th January 2021, where it has been specifically stated that a decision has been taken not to shift the primary health center from Kundur village, KR Taluk, to Milna Haldi village,
Mailana.
Mondia district. In view of above, the petition does not survive. It is accordingly dismissed.
7 January 2022. 2022.
Please, ma'am.
Accordingly disposed of.
Number 20. Sir Clifton D. Rosario.
I appear for the petitioner in this matter, my lord. My lord, the matter pertains, my lord, to a various number of issues relating to crop insurance, my lord. The petition was filed, my lord, by the petitioner, which is an organization of farmers, and pertains, my lord, specifically to the failure to disperse crop insurance under the Pradhan Mantri Fasal Bima Yojana, my lord. My lord, the matter has been taken up, my lord, by this honorable court via order dated 11th December 2020 as a continuing mandamus, and a number of orders have been repeatedly issued by this honorable court, as well as there have been a number of compliance affidavits by the respondent state and as well as at the center, my lord. May I be permitted, my lord, to file my submissions in respect of the orders passed and compliance taken thereon?
As regards the balance compliances, madam,
Yes, my
or
lord.
are they all complied?
Yes, my lord. Regarding balance compliances, as well as certain interim applications have been filed by me, my lord, and objections have been filed. If I may be permitted to file my written submissions, then I may take your lordships through the same.
Learned counsel for petitioner principal is allowed 2 weeks time to file the affidavit indicating the compliances which are still required to be made by the respondent.
Obliged, my lord.
7th April.
I pay for the second respondent. Today I had filed the power for the second respondent. Kindly have 2 weeks time to file my objections.
There is direction to dispose its RP, my lord.
Whereas same time where I had filed it.
By the FX code. Annexure E, page 67.
The current applicant who authorized you to continue with the booking.
2 weeks time to file the objections. Mr.
21/3.
May I make an appeal to your lordship? The impugned order may be stayed.
Where I had filed a contempt petition, first respondent had modified the order. And appointed him.
The impugned order is passed based on the document, fabricated document, Annexure F is referred in the order. Kindly see the order, the file, original file.
We'll have to hear the state also.
Please.
State will have to be heard. It's a question of what is your vested interest to be in that post. We'll have to see that. Let them file their objection.
But in fact, in view of the order, my lord, passed by division bench of this honorable court, that way back in 2011-14, that this review petition is not made.
File your objection.
That is subject to Supreme Court order.
But that has not been brought to the notice of the honorable Supreme Court.
That we can know.
Please, my lord.
21/3. Number 22.
Prakash B. I 2 weeks time to official my application. 2 weeks time I comply in official petition, my lord.
Counsel for the impleading applicant seeks for 2 weeks time to comply with the office objection. Leave it. They are pending IAS. They are pending IAS. Today it's come up for learned counsel for respond number 14 submits that he has filed IA number
2.
Make a list of it and give it. Which are pending consideration. Registry is directed to put up the same.
With kind permission, my lords, it's a corrected matter 22.1. I have also filed an application 1 of 22, my lord. Kindly grant me 1 week time so that I can comply with this objection.
22.1, learned counsel for the applicant in IA 1 of 22. Please seeks for and is granted 2 weeks time to comply with office objection.
Great.
ಯಾವ್ದು ಬಂದಿದೆ? When did you get it? Not taken on record. It's not taken. Shagan Kumar.
These three supposed to be.
Twelve 2021 and 19/1/2022 have been received from Justice Sri Devi Sharan Kumar Committee. The same are taken on record and shall remain in a sealed condition until the matter is taken up in the custody of the registered judicial.
March.
Only have 16th March.
Yeah, 1/6.
Number 23. The Ganapati Bhatt.
I have filed application for production of documents. That is, my lord, subsequent events, my lord, statement made by senior judges.
Any objection?
Application copy is not served.
Application government without serving, my lord, I'll serve once again. My lord.
It was manual AGA submits that he has not received IA-1 of 2022. Let us ask for the petition undertake to furnish the same within a week. Relist after 2 weeks.
15th March. Number 24. Sadiq Chandra.
With my application, Lord, was to correct what appears to be a defect on the prayer. Because I sought for a Lord of declaration. Because I sought to amend and seek Lord the writ of certiorari. Because in fact, Lord, your question is whether jurisdiction lies at all. So, Lord, should feel that declaration is appropriate. Because, my Lord, what has been done is a grant order prior to the 2015 amendment is now sought to be rescinded, my Lord, by the improved order, taking away my right under section 18. Lordships will say, my Lord, the prayer is.
Any objection to that?
No.
But also,
counsel for the petition has filed IA-1 of 2022 seeking for amendment of the first paragraph of prayer A in the writ petition by deletion of the word declaration and replacement of the same with the word certiorari. There is no objection filed, nor is there no objection filed to the said application. S.S. Mahendra fairly submits that he has no objection to allowing of the said application. Accepting the same, IA-1 of 2022 is allowed. Counsel for the petitioner is permitted to carry out amendment of the petition and file amended petition within 2 weeks from today. After service thereof and counsel for the respondent.
May I make one more submission? Because on the last date, it was said that petition is not maintainable and objections are not being filed on the ground that there is a revision available. That is, my lord, covered by a Supreme Court judgment. May I place that so that, my lord, on the next
You
day?
place it on the next.
We will consider after you make.
Very well.
25-3. Number 25. So Madhukar, please, Pandey.
If I appear for the respondents, I have filed an application for listing. A date may be fixed.
Third one, IA-1 of 2022. List on.
Your Lordship, can I request for 9th of March?
15th March.
15th March.